had the new, a new, relatively new concept. And that is the concept of resentencing, which deals with a situation where somebody has already been sentenced and their sentence is then put under review. Now, just going back a bit to sentencing as opposed to resentencing, one of the things that necessitated the coming up with policy guidelines was that huge disparity between cases that were considered to be like cases. You find a person has been charged with a particular offense, and the facts may be very similar. So not just the fact that the offense that has been charged is the same, but the facts surrounding the commission of that offense may be very similar. Yet you may find a situation where somebody is given, say, a custodial sentence of 6 months, and another one may be getting 3 years. And so there was need to just bring that together. Then there was, of course, the other clamor for a departure from mandatory sentences. And for those who are practitioners of criminal law, you may be familiar, you must be familiar, first of all, with the offenses that have, before the Morotato case, called for a mandatory death sentence. That is the offense of murder. And also, although we have not seen this in Kenya in many years, perhaps close to 40 years, there has been the offense of treason. But the point that is being made here is that those are offenses that have attracted a mandatory death sentence, notwithstanding the fact that the last time that sentence was carried out was in the year 1987 in the case of Senior Private Hezekiah Ochuka, who had been essentially charged with having been the person behind the 1982 abortive coup. Now, 2017 brought in the new creature that is now the resentencing. And this was within the context of Morotato, the Morotato case. It's a case that involved two petitioners before the Supreme Court. I forget the name of the other, but as is the case with most cases, only the first person keeps on getting remembered. And this is called the Morotato case, despite the fact that there were two petitioners. And in that case, the Supreme Court affirmatively made recognition of the fact that the death penalty need not be a mandatory sentence. And that, I think at the time was thought to be something that was going to unlock a lot of situations. But as we might have seen, those of us who practice at the criminal bar, this has also happened to be a can of worms. It has opened a can of worms for those people that now require resentencing on account of the death penalty having been meted out. Sorry, the death penalty, the death sentence having been handed on to them. And they think that now there are circumstances that exist for challenging that death sentence and perhaps getting a custodial sentence. Of course, let me start by saying that right from the get-go, if since 1987 we have not hanged anyone, which is what the death penalty in Kenya requires to be done, then I think we are not being fair to the whole system of administration of justice if we are sentencing people to death and not hanging them. And I want to make myself very clear by saying that we're not being fair. I'm not saying that those people deserve to be hanged. No, because first of all, I'm a firm believer in the eradication of the death penalty. What I am saying is that you cannot allow people who are running two sentences at the same time. One, which is a sentence in suspension, because technically speaking, the convicts who are on the death row are still legally liable to being being hanged, but at the same time they are serving a custodial sentence. I don't know whether it's a life sentence or it could be a life sentence. It could be just an indeterminate sentence that they are serving alongside the death sentence, which is a sentence that is in suspension. So that is where the unfairness of it comes in. So you may be aware, and I want to hope that this information has trickled down to Langata Women's Prison, and not just to Langata, but to all the prisons across the country, that at the beginning of last month, I believe it was on the 6th of July, there was a revisiting of the Morotato case, which I think ended up throwing even a bigger spanner in the works. And if I may just read out a bit from there. The appeal, yes, it involved two appellants, Francis Karioko Morotato. The other one is actually Wilson Thirimbo Mwangi, who had been convicted and sentenced to death for the offense of murder. And they had then challenged their sentence before the Supreme Court. What they were challenging was the mandatory nature of the death sentence, and the Supreme Court had agreed, yes, that the death sentence should not be mandatory. But in the revisiting of Morotato last month, it does appear that the death sentence or the Morotato case now came to even further limit the scope that had been given by the court in 2017, and this has brought immense confusion. And I was just, as I was looking at the presentation today, I looked at some two matters that have been decided in the High Court recently. One is the case of Andrew Amatala versus Republic, which was decided on the 26th of July. That's just about 5 weeks ago. And this is a case where the accused had been or let's call him the petitioner, because he had gone to court now as a petitioner. But in the trial, he had been tried and convicted on 2 counts of robbery with violence, which, as you know, before Morotato attracted a mandatory death sentence. And then the 3rd count was a count of gang rape, and he was sentenced to death for count number 1 and 2, and life imprisonment for count number 3. And in fact, one of the bits of confusion, not quite related to Morotato, was that it had been ordered that the sentence, that's the death sentence, in connection with the robbery with violence, would run consecutively with the sentence with regard to gang rape, which was life imprisonment. So you don't even understand. When you say it will run consecutively, it means that one would have to run its full course, and then the other one starts. And obviously, if life sentence, as we know it in Kenya, runs its full course, its full course ends at death. And therefore, the other sentences, the death sentence in respect of the robbery with violence cannot be carried out. If you look at it the other way around, where you start with the death sentence, if it were to be meted out, then you find that, again, the life sentence cannot be carried out. But that's aside from the discussion today. But what happened in that case, just in sum, is that the Honorable Judge of the High considered the sentences within the Morotato case, and held that although the court hereby upholds, let me just read out, hereby upholds the conviction and sentence of the petitioner for the offense of robbery with violence and gang rape, it hereby orders that the period the petitioner spent in custody, if at all, shall be taken into account when computing the life sentence in accordance with section 333, subsection 2 of the Criminal Procedure Code. And for the reasons that she gave, she found that the court's decision was that the petitioner's petition was merited and that it ought to be allowed. That's on the 26th of July. Just before then, on the 15th of July, which was 9 days after Morotato 2021, we had another case, and this is in the High Court in Albrecht, brought in as a petition also, Daniel Mwomole Adebe versus Republic. And in that case, the judge, the resident judge in Albrecht, still applying Morotato, held that the only option available for the petitioner would be to appeal to the Supreme Court if need be, and that taking into account the constitutionally established hierarchy of courts, this court, and that is the High Court, has no power to revise the decision of the Court of Appeal. This then is the end of the road for the petitioner. He must make peace with the decision of the Court of Appeal and serve his sentence. In the result, the petition is untenable and hereby dismissed. I brought out those cases, those 2 cases, just to show how we have brought into confusion the whole question of sentencing and resentencing. And one of the things I think we should be thinking about is how then to have a sustained and structured conversation on sentencing and resentencing to integrating guidelines on resentencing into the sentencing policy guidelines. I started that way so that I just provoke a bit of thought into this, and I will stop there for now. I don't know if I'm being heard. Am I?
Yes, yes, you are.
Thank you.
Thank you so much, Senior Counsel Mderitu, for that insightful those insightful words when it comes to sentencing and resentencing. I'm sure there's much more that can be shared, and thank you for trying to compress it in a very easy way for anyone to understand. I'd like to acknowledge some of our followers who I can see the Office of the AG is represented, Miro Prisons. They're still following the conversation. Kindly share the link to those people we feel will benefit from this discussion. It comes once in a while, and I think this is the best time that you can tap into this. So without much ado, I want to welcome our next panelist. But before I do that again, please make use of our chat box because we won't be having an open forum where you'll raise your hand and be given an opportunity to speak. We utilize the chat box. Take down your questions and I will pick them and they'll be addressed. Kindly make use of the resources that we have amongst ourselves and get the issues that you have addressed. So next, we have our second panelist for the day. As I continue waiting for the questions on the chat box, today we are joined in by Mrs. Jemima Teresia Collins Aluda. So I will take you through the her bio. So Mrs. Jemima Teresia Collins Aluda is a consultant of rule of law and accountability and managing partner at Jemima Collins and Company Advocates. Currently, she's consulting at the UN. Currently, she's consulting at the UN Women on the Convention on the Elimination of All Forms of Discrimination, CEDAW, and has consulted with the Office of the High Commissioner on Human Rights, Kenya office, on police brutality, on police accountability and extrajudicial matters. She's developed a rapid reference guide on alternatives to prosecution. She's served as a principal prosecution counsel at the ODPP for 9 years. She holds a master's degree in law from the University of Nairobi and Masters of Arts in project planning and management from the University of Nairobi. As a prosecutor, she developed tremendous jurisprudence in criminal justice sector. She was the technical officer on the formulation and enactment of the Elections Offences Act of 2016 and represented the office in the Chapter 6 Committee on vetting of aspirants during the 2017 elections. Key achievements during this period was development of standard operating procedures, SOPs on election offences, conciliation guidelines on hate speech cases, checklist on electronic evidence, and sample charges on election offenses. She has been instrumental in the development of diversion policy and plea bargaining guidelines and explanatory notes. She represented the ODPP in the task force on development of alternative justice system policy, which enhances the use of alternative and traditional justice mechanisms to address conflict. She's also a trainer on sexual and gender-based violence and has trained law enforcement agencies, horticultural workers, the defense forces, and other medical practitioners on Sexual Offences Act on addressing the gaps in investigation and how to curb the vice through effective prosecution of the perpetrators. She engages in enhancing access to justice for women and children. She's a trainer on electoral and related offenses and alternatives to prosecution, including diversion, plea bargaining, and deferred prosecution agreements. She is a trainer on devolution at the Kenya School of Government, where she's been advancing the gains for women in the devolved system and opportunities that women have. She has been engaged in various consultancies, including development of SOPs on investigation and prosecution of serious human rights violations committed by police officers, development of rapid reference guide on prevention of torture acts, preparation of the alternative report to the Committee on Convention Against Torture and the Committee on International Convention of Civil and Political Rights, development of ODPP child prosecution guidelines, and development of the 4th edition of the MOH training manual on management of sexual and gender-based violence in Kenya. She's also been involved in the development of the ODPP plea bargaining guidelines and explanatory notes, development of conciliation guidelines, and development of ODPP diversion policy and diversion guidelines. Lastly, she is a member of the Interpol Fisheries Crimes Working Group, where she spearheads combating human trafficking at the sea, and also served as a board member at the Federation of Women Lawyers, that's FIDA Kenya, in 2018 up to 2020, that's last year. And she is a trustee at the Riara Road Parents Teachers Association. Again, join me in welcoming Mrs. Jemima Teresia Collins Aluda. Karibu sana.
Thank you so much, and thank you for that introductory bio. Ladies and gentlemen, welcome. I hope I can be heard clearly. So I want to take you through plea bargaining, and I'll be using slides, so you'll be able to follow, to walk with me through the slides. So on the introductory is just to understand what plea bargaining is. And so for an effective criminal justice system should be able to deliver a response to those who break the law. We appreciate that, but we need to look at both imprisonment and non-custodial disposals options for offenders, so that we don't really focus on only custodial measures, but look at non-custodial. And I'm glad that Senior has been talking about the sentencing policy, which advocates for various forms of policy of sentencing. But here we are trying to see how can we be able to deal with matters without taking them to court. On 2nd of November 2015, President Barack Obama, in his speech on criminal justice reforms, intimated that there were by that time there were 2.2 million Americans behind bars. I'm sure we have the statistics for Kenyans in terms of those who are in custody and those who are those who not been able to pay for bail pending trial, bail pending appeal, and those who are serving sentences. And so around the world, he was saying that you have 70 million Americans, we have so many more. So 70 million Americans have some sort of criminal record. When we emphasize on taking people to court, what we're looking at is criminal record. And all of us know that at this particular time, everybody is being asked to get a police clearance. And so people are even hesitant to give their fingerprints, even if they're just walking through the trial and they're found not guilty. They still believe that perhaps the criminal record is still within the DCI or the police. So it disqualifies you from participating fully in society. And in this regard, so we need to look at reforms so that we can have a fairer criminal justice system. In this regard, as you talk about criminal plea bargaining or alternative forms of prosecution, we are talking about the balance between restorative justice and retributive justice. So the main approach of alternative prosecution, which plea bargaining is one of them, is about restorative justice rather than retributive. So restorative justice focuses on the crime as an individual, as an act against an individual, rather than retributive justice, which looks at a crime against the state. So we want to focus on you have committed a crime against an individual, and you can be able to resolve this crime outside court, rather than you have committed a crime against the state, and so it is the state that must punish you. So typically it brings the victims and the offenders together to decide on the most appropriate response to the harm that they've committed. And that's why sometimes even after somebody has been convicted and sentenced, the victim still says, mimi bado sijaona kama nimepata haki. Nahisi kwamba bado ile uchungu niko nayo. So to the victim, as much as the state has taken its arm and has sentenced this person to prison, the victim still feels like there's something more that needs to be done. that yani angekuwa tu ameniambia pole, angekubali mashtaka aniambie pole, ama angekuwa tu ameniregeshea gari yangu ama niregeshea pesa yangu. I know now in the social media we're talking about issues of those who make money falsely. So the victim still feels like I've not been fully compensated, or this thing has not really covered me so much as the person has been taken to prison. So importance of the restorative justice, which plea bargaining is one of them, is looking at helping the youth. We have the youth offenders who, yes, they've committed offense by the fact that they're young, and then their records are kept in for a very long time. We've not yet come up with a system that says your record can only be in police custody for maybe 2 years, and then after that, you can be declared not a criminal. So our records are still there. There's no system of that. So when you go there, you still find your record. And that's why we've had these challenges of Sonko being told you are convicted in this year and you've never, finished your sentence, such kind of things. Yeah. Sorry to use that as an example, but not on a political note. In the community feels like this person, yes, we want to participate in perhaps reparating the person so that he can be a better citizen. Then it helps the victims. The victim feels like you've participated in telling me, sorry, you have compensated me in some sort, you have taken care of, the injury that I got through, maybe the assault. And so the victim feels like, yes, we have participated. Then it gives alternative to incarceration, whereby we are talking about so many people are in custody until at some point people say that we have so many men locked in custody. That's why we don't have men to marry our girls. So that's just as a by the way. But it helps to give us an alternative to incarceration. So can we have alternatives instead of just forcing these people through the criminal trials and at the end of the day, convicting them and sentencing to jail? Then it gives prosecution and civil protection to the state. So just to mention, it's just one slide to mention other forms, but today we are focusing on plea bargaining. We have plea bargaining as a form of alternative to prosecution, diversion, conciliation, informed warnings, whereby you've done a mistake in somewhere and then you're told, iwe funzo tafadhali, next time don't repeat, like the simple trafficking offenses, cautions, whereby people are cautioned, compensation to the victims, transitional justice mechanisms, as you've heard, we formulated the edges, policy that looks at other forms that we use traditionally in terms of resolving conflict. And lastly, deferred prosecution agreements, mainly used when you're dealing with companies in money laundering and economic offenses. So ladies and gentlemen, what is plea bargaining? It's a negotiation between an accused and his advocate on the one hand, and then the prosecutor on the other hand. So we have an accused and his or her, his advocate or legal representative. And in this regard, the accused is pleading guilty or to some charges or to all charges or to some crimes. So that in reduction, you get maybe reduction of sentence, removal of the charges, or some recommendation that you come up with the prosecutor. You agree, you get some benefits. So that's why it's called a plea bargaining. It's a bargain that you get in. In additionally, an accused will reach mutually satisfactory disposition of the criminal case, subject to court approval. So you present the bargain to the court. Then it can conclude a criminal trial case without any trial. If it is successful, it results into a plea agreement. So we have plea bargaining as a process, and the outcome of the plea bargaining is a plea agreement. So what is plea agreement? It's also known as a plea deal. In some jurisdiction, they call it plea deal. It's a accumulation of the plea bargain process, like culmination. At the end of it all, once you have bargained and you are in agreement, then you sign something called a plea agreement. So once the prosecutor and an accused person gets into a complete bargaining process, they record or come up with a plea agreement. In this plea agreement, I'll be able to discuss further on some of the things that you can be able to agree between you and the prosecutor or the state. So ladies and gentlemen, just to give us a brief history. In 2008, so plea bargaining is not something that has just come up this year or last year. It started in 2008 when the Criminal Procedure Code, section 137A to 137O was inserted. There was an amendment to the CPC, and it will introduce section 137A to 137O. So initially, we used to have just plea bargaining on murder cases, reducing murder to manslaughter cases. We didn't have plea bargaining where we were looking at a reduction of sentence, of maybe removing some charges against an accused person, and you're recommending some charges like some sentence. So it was just a reduction from murder to manslaughter sparingly. But in 2018, through Legal Notice 47, the CPC, Legal 47 of 2018, the DPP introduced the plea bargaining rules in section 137 or I'm sorry, I'm in a hotel whereby it's next to a road. And so in section 137 or specifically, it required the DPP to develop rules to operationalize the plea bargaining laws. So this took over 10 years from 2008 until 2019, when the ODPP now developed the plea bargaining guidelines after extensive work, which I participated. And there was a validation both internally and externally, and that's why now we have the plea bargaining guidelines that you've seen. When you Google the ODPP website, you'll be able to find the guidelines which are now operationalized the section 137 of the CPC. Under article, the legal framework is very brief also. We are relying on article 157.9 of the ODP of the Constitution, which gives the DPP constitutional prosecutorial authority to prosecute. Article Act number 3 of 2008, which amended the CPC, and then Legal Notice 47 of 2018, which now the DPP was able to gazette the plea bargaining rules. And then under the ODPP policy, it provides national prosecution policy. It provides for the DPP to use alternative prosecution, so that plea bargaining is one form of that alternative. And so the question is, when can the plea bargaining be used and when can it not be used? Because we can't say that it just stands on its own, that you can use plea bargaining at all time. So first of all, when the parties are convinced that there's evidence. So first of all, the DPP must ensure that they have evidence. That is the first thing. Then number two, the parties have a joint recommendation on sentencing. So if you've not been able, it's a bargain, give and take. So as you bargain, you have concluded on the recommendation that now can be used. When the parties have different position on sentencing, so you can also have different position, and then the court will be able to make a determination. Sometimes you can bargain and agree, but you see, the issue of sentencing, I'll bring it as a challenge, still relates to the court. And then when the accused is ready to admit the charges under oath and voluntarily, it should be a voluntary process, not a forced or coerced process. So when can it not be used? Number one, you cannot use it when there is insufficient evidence. You cannot force somebody to bargain when you don't have even the evidence. So it is important that as lawyers, we see the evidence, look at it, analyze and confirm that indeed this evidence is incriminating my client, and there's sufficient evidence. So in that regard, you can be able to get into a plea bargaining. It cannot be used where a decision has not been made. So first of all, there must be a decision to charge. So unlike other forms of alternative to prosecution, like informed warning, whereby you just meet a cop in the street and he tells you, I'm not taking charge, don't overspeed, to charge, and a charge sheet has been drawn, and even somebody has taken plea. Once the person has taken plea, then you get into the bargain. Diversion, you can do it before plea taking. AJS or traditional mechanism, you don't go into plea, but in this regard, there must be a charge, addition to charge that has been made, and somebody has pleaded guilty, then has been charged in court. Then in that regard, you can get into a plea of guilty. It is not a confession, but a voluntary admission of guilt. So it's not a confession. Don't equate plea bargaining to a confession. It is not shortcut to justice, and it's not a scheme to get the innocent people to forfeit their rights. So it's not a scheme that prosecution or the police should get into, so that the innocent poor people who are informed and ignorant actually just end up to plead guilty. Ukisha plead guilty, I hope all of us can understand Swahili. I like mixing Swahili and English because that's the national, those two are the national languages that we have. So you don't use that as a scheme between the prosecutor and police. Kumwambia mtu nenda tu ende plead guilty. Ukisha plead guilty, tutaangalia mambo ya sentence. So sometimes there's that shortcut that is being used. Then it's not a secret agreement between the prosecutor and the accused. Remember, it must be presented in court, and the court must be able to look at the agreement and ascertain and be able to sentence, convict the person and sentence. It's not a scheme to benefit the wealthy to escape justice. So sometimes the wealthy people can say we use plea bargaining because of the way they go. Wakishasema wamekubali mashtaka, and then wanaambiwa you're going to be given community service. And lastly, it cannot be used when the accused maintains innocence. Okay, so who are the participants in the process? The participants in the process are very clear. Must be the prosecutor, the accused person, who is either an adult, a child, a person of unsound mind. I'll be able to elaborate this when it comes to the legal representative. The legal representative, like the lawyer, family member, paralegal, guardian, investigative agencies who must be involved in the process, the NPS, the ESCC, KRA, and any other agency that undertakes investigative role. The victims can be companies, government, individuals, families. All these can be victims, and children officers and probation officers. So for purposes of today, because of the time, I didn't go into issues of children, probation officers, or investigative officers, just a brief role on who plays what. So for the judiciary, they're not party to negotiations, but it is an independent examiner once an agreement is reached between the prosecutor and the accused person. So the judiciary cannot be participating in the plea negotiation or plea bargaining. So the court retains the power to accept or reject a plea agreement once they know that perhaps it was coercion. And that's why the court will ask the accused, did you do it? Are you okay? Do you charges? Do you understand that once this has been read to you, that the offense will be, the sentence still remains the power of the judiciary. So they have to be very independent. So before rejecting or accepting a plea bargaining, the court does that. It considers the terms of the agreement. What are the terms? Are they the terms within the law? It verifies that the accused person is pleading as a result of an informed choice, like you've been informed, you understand. It's not, you've not been coerced, and then it considers the submission on sentencing. So remember, sentencing, it's a proposal whereby the prosecution proposes, but remember, sentencing still relies as the power to the court. Then the role of the prosecutor. Prosecutor plays a very big role in this. First of all, he looks at the public interest, that it must understand what is the public interest in this particular test, and how should I apply such public interest to be preserved. That is one of the best things that the prosecutor looks at. Then number two, cost-benefit analysis of the time, unnecessary trials, protecting the innocent victims, protecting also even the accused. Because sometimes, like we had a scenario, this is a case that ended in Kiambu. In this case, whereby one of the accused person, indeed, he's the one who murdered, but he murdered under the instructions of the wife to the deceased. And so this person was ready to plead guilty because he said that, yes, we were informed to do this and this, and he was able to not, and he wanted to participate in terms of giving evidence even in court. And so he had to get a lesser charge of sentence of about 3 years. While he was serving the sentence, then he was able to testify. But in this regard, it was done because of the issues of the public interest, cost-benefit analysis, and even protecting both the accused person at that particular time, who is now the person who went into plea bargaining, and the victims, who are now the children to the deceased. So you must have the latitude as a prosecutor to fulfilling the plea bargaining before it is accepted by the court. That is on the first place. Then you are bound to carry by the promises. So if the prosecutor has promised that during sentencing, this is what I'm going to present to court, you cannot allow the accused person to sign. Once the accused person has signed, then you go against what you have agreed. So that is a must for the prosecutor. Looking at the roles of the advocates, and I'm sure that we're here because we want to know what is our role. So presence of an advocate or a legal representative is to assure the court that a guilty plea is truthful, based on informed consent, entered with an awareness of the consequences and the rights of the accused person. So as much as you are representing your accused person, your role is to ensure that it is truthful. It is informed consent. The person is entering into this consent well aware of what he needs to do, what his rights are, and what are the consequences. So you act as equalizers in the plea bargaining mechanics, and you advise the client or the essence of give and take. So your role, or our role as the lawyers, is to advise our clients on the give and take. What are we giving? What are we taking? And let me just inform you, plea bargaining must not necessarily end into a conviction. It can end into the dropping of the charges of your client, so that your client can be used as either a witness, because of the role they played is very minor, a witness in court, or even perhaps they are victims of circumstances. So you should be able to recognize your client's rights, respect the rights of your clients, assist them in making the choices themselves, and trust the knowledge and judgment in the negotiation process. So that is your role as an advocate. Before I go further, we want just to understand what are the benefits. So I'll just rush through the benefits from the prosecutor's perspective, accused person, and even from the prosecutors, it provides greater flexibility in handling criminal case loads. It gives you that flexibility so that you're not always saying about files, witnesses don't turn up. Allocates scarce resources to other more trial-worthy, offers a quick, efficient method of resolving disputes, and ensures a conviction is reached and justice is served, where plea bargaining has resulted into a conviction. To the accused person, avoids time-intensive or potentially costly. I did a case in court whereby it was an SGBV stroke robbery with violence case, and it had been in court system for 10 years before the trial ended. And then now on appeal, it took 3 years to come to the High Court appeal. Then, of course, by now, I'm sure in the Court of Appeal, they've not even handled the Court of Appeal matter. So, time intensive, which is costly, because every time you have to spend money, people have to come to see you in court or in custody. So it takes that time. Then it removes that anxiety, uncertainties, because I know that when people are in prison, they're always wondering, when will I ever get out? When will this come to an end? When will I ever get maybe convicted or acquitted? So that anxiety, it results in lower sentences in exchange for acknowledgement of guilt. For instance, murder to manslaughter. When you reduce murder to manslaughter, in most cases, I used to see that somebody is given 1 year sentence, 2 year sentence, sometimes 10 year sentence. So it reduces that lower sentences, and then benefit to the community, disposals of the cases to the judiciary, quickly and efficiently disposing cases and consult judicial resources. Remember, we always pay people coming to court. We pay the interpreters, we pay the translators, we pay for resources, we pay for people, the witnesses coming to court and all that. Reduces buildup of cases, the backlog that you always talk about. And lastly, shortens time, which leads to case management. To the victims, of course, we can't leave the victims out. Knowledge that the accused person not go and punish. So the victim just wants to know, huyu amekubali hiyo tu. Kuna wengine wanataka tu mtu akubali, and that's it. So they know you'll not go and punish. Allows an immediate sense of closure and avoids time consuming and uncertainty. There's this victim who will be coming to court for the last 5 years. Atakuwa anafuatilia kesi yake. Walisema ni kesho, atakuwa anakuja kotini till the end. Then compensation to a victim possibility allows victim to make representation to court. So it is only through plea bargaining that the victims are fully participate in the trial, in the process. They are informed to plea bargaining. Can you see what this person is saying? I've participated in some plea bargaining, and this is what actually happens. Then lastly, to the public, we are the ones who pay all this money to the taxpayers, using taxpayers' money. So it consults public resources, reduces or eliminates costly trials paid by taxpayers, provides a final and definite resolution of the matter. It's definite. At least there is somebody can say we can appeal, but you only appeal on sentence, but at least there's some definity in this finality. Convictions, convicts criminals quickly and efficiently, then builds confidence in the criminal justice system. There are those people who just say, at least through the plea bargaining, koti siku hizi zinafanya kazi. Koti zinakamilisha kesi. Maanake wakitembea kwenda kotini kila muda, wanasema kwamba hizi koti, you can't get any justice in court. Now, I want to walk with you through the plea bargaining process. Hey, this has really been like a training. So there are very few process: initiation, consultation, negotiation, then form of plea agreement recording, then rejection, termination, and finally finality. So in briefly, I'll walk with you through these stages of plea bargaining. In the initiation, what we ask ourselves, who can start the process? The process can be started by the accused person, prosecutor, legal representative, the accused person, or any other person who sees that at least there is need to start plea bargaining process. So the role of the court, when the parties intend to negotiate, they will notify the court, then the court shall not participate in the plea negotiation, but shall know that at least there's a process that is going on. You can also tell the court, maybe you're seeking an adjournment because you are doing some negotiation. So the court should be able to grant you that and a negotiation. So you can, if you want to do it in writing, you must write the date and time of the meeting, when you want to do the consultation, the venue, the parties to be present, then request for the documents that you want to use, then provide the accused person with witness statement so that, and documentary evidence, so that your role is to confirm that the witness statement actually point to guilt of my client. In order there is sufficient evidence. As I said, it's not a shortcut to have the innocent people plead guilty. Then you have some timelines, like 30-day deadline, but depending on the matter, for instance, in economic crimes, it takes a long time. In Nairobi, whereby you're told that you must be able to write to the DPP to give consent, sometimes it takes longer than 30 days, but at least in our county offices, it's the county head who has the charge. So you give some time, it is faster and easier dealing with it in the counties. Then you go to the consultation stage. In the consultation, a prosecutor shall only enter into plea agreement in accordance with section 137A(o) to O of the CPC, as I said. So after you consult with the investigating officer, the victim, the legal representative. You look at the opinions of the victim, but they're not binding, because sometimes victims will just say no, 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 no. So at least you must be able to have the victim, the regards to what the victim is saying, with due regard to the nature, circumstances relating to the offense. How did it occur? What are the personal circumstances? Are there interests of the community? So we call this the three tests under the National Prosecution Policy. Evidential tests must be met. Public interest tests must be met, that indeed it is the public interest for us to get into this plea bargaining. And lastly, the threshold test, that if you are the two, you go for trial or you go for plea bargaining, then you find that it is easier to go for plea bargaining. Then negotiation. Lastly, so next we go through the negotiation stage. You maintain a full and accurate record of the plea negotiation, that it must be you must be having some minutes, something written. So anytime you have meetings or consultations and negotiations, you must have them done. It's joint meetings of all the parties in the plea negotiation where the circumstances permit. For instance, sometimes you can have the legal representative of the accused person, but the accused person is not there. So your role as the legal representative is to inform the accused person, this is what we had. But in most cases, we try as much as possible to have participation of all the parties. I'm sure that for the past 2 years, this has not happened because of the COVID and the restrictive measures that we've had. We only handle when the accused persons are actually out on bail. It has been easier, but those who are in custody, it's not been easier. So I think it's important the DP to devise mechanism whereby you can participate with the accused person in custody. So you have letter that is initiating the negotiation that has been done, then consultation, have meetings, look at the mitigating and mitigating circumstances that you can say, my client committed this offense under these circumstances. Then there must be an offer and concession from both parties. So what is your offer? You give your offer that I want my client to be acquitted. I want my client, I recommend an out-of-court sentence. non-custodial sentence, I recommend maybe 2 years imprisonment or 1 year in prison, looking at the circumstances. Then you get into a form of a plea agreement. Now, once you've done the negotiation, you get into the plea agreement. So the next one is the plea agreement. And when you get into this plea agreement, make sure that it is in writing, it has been reviewed, accepted by the accused person. I don't know if I'm still in. Am I still in? Yeah, okay. So
yes, we can hear you.
So it shall be in writing. Okay, it shall be in writing, shall be reviewed. Sorry, the computer that I'm using to share this the slide, I think it's ahead of this other one. Yeah, so, okay, so it shall be in writing, it shall be reviewed and accepted by the accused person. It's explained to the accused person in a language that he understands. Kama ni Kiswahili, mweleze kwa Kiswahili. Kama ni lugha ya kimama ambayo tunasemanga our mother tongue, you must explain to the accused person in that mother tongue so that they understand what it is. Then it should state fully the terms. What are the terms of the engagement? What are the facts and other material relevant facts? Should be signed by both the prosecutor, the accused person, or his legal representative. Kama unasema utalipa huyu mtu pesa fulani, lazima huyo victim akuje assign, or the complainant. Because sometimes when you sign or you get into this plea agreement, then when we sign, the complainant is not aware, then this person does not pay any compensation. Then you record the plea agreement. And how do you record the plea agreement? You present it in court. When you present it in court, then the court will be able to read to the person again. And once the court reads the person has accepted the plea agreement, says that I recorded it, I understand everything, then I'm ready to take the plea, and plea bargain is done now in court. So you inform of the maximum penalties, including imprisonment, fine, community service, probation, conditional or unconditional discharge. Any other forfeiture that is needed, the person must be informed. You must be informed that you are waiving your right to appeal except on the legality of the sentence or to the extent of the sentence. So you inform all these rights. And then the prosecution has the right of perjury or false statement if they have used against the accused person. The same is recorded and presented to and informed to the accused. The accused person is informed. Then it is signed and initiated in each and every page. So we have to initiate each and every page. And in case of a child, it's done by the children officer or probation officers or the legal representatives in court. Sorry, legal representative of the children officers. So you must be able to sign and initiate in all the pages on the agreement that you have entered into with the DPP and shall be binding upon acceptance in court. Now, you can terminate the plea agreement at any stage within a reasonable time. If it's not completed and umeona kama haikupeleki mahali, you have a right to terminate. Then if you terminate but you want to reinitiate, it can still be reinitiated. I'm saying you can terminate at any time before completion. But at some point you want to reinitiate the process, you still have a right to reinitiate, right? Like right now I have a plea bargaining that I've reinitiated that had been terminated earlier some 2 years ago, but now we are still reinitiating we've started the process once again. So if there's breach of any terms of the agreement, it can call for termination of the plea agreement. Then prosecution shall not agree to a factual basis of a plea which is misleading. You must be able to agree on bases that are not misleading, and that's even our role as lawyers. Then that plea agreement, if it's concealing material facts, then you have a right to terminate the plea bargaining process. So another ground for termination can be because death of the accused person, then withdrawal of a plea agreement, plea of guilt pursuant to section 137K of the CPC. Confidentiality as to the information received from the prosecution applies. Anytime you're doing this and you want confidentiality, you must ensure that you maintain, because sometimes an accused person wants to enter into a plea bargain but fears that if I do this, it's a co-accused. When the other people hear that I want to do this plea, my life is in danger. So you must ensure there is confidentiality at all particular points. We can even send a confidential clause whereby the people don't know that this person is entering into a plea bargaining. Then if termination is due to misrepresentation by the accused person, matter proceeds if there was no plea of guilt and no further plea negotiations can take place. So if the accused person did not give you full information, then you terminate, then you just proceed with the case until completion. Lastly, ladies and gentlemen, I know that I've taken so much of your time. What are some of the challenges? Lack of adequate mechanisms and infrastructure to access alternatives prosecution, e.g. legislation. We don't have, other than plea bargaining where we have a specific legislation under the CPC, 137 A to K. We do not have any other legislation on alternatives to prosecution. We've done just the AJS policy. But as I've informed you, we have other forms, I'm sure that we were not looking at today, like diversion and informed warnings and conciliation. We don't have specific legislation that deals with alternatives to prosecution. Then an unwillingness to exercise alternative prosecution by parties, like we are not willing to take plea bargaining. For instance, for the lawyers see that, oh, you know, by the time I'm going to court, every time I go to court, I get some attendance fees. But now you see, when you go into a plea bargaining, once you've agreed with your client about the legal cost, you take through the plea bargaining process, then you're able to end the trial. I'm sure most people see criminal procedure, criminal trials or taking criminal cases as not a lucrative part because they take longer, so they go for civil. But we can make it lucrative if we're able to even handle these cases within timely, through the alternatives, through the plea bargaining, finalize the case, get our legal fees, and be able to move to the next one. So that one I'm talking to the lawyers and not any other person. Then you not pay attention to personality of individuals and circumstances under which somebody enter into the prosecution at the early stage. For instance, the young people who have been found like drunk and disorderly, like there's some cases there's some areas where drunk and disorderly is the main case. But now we are still taking them to court. These people need more of rehabilitation. They need more of counseling sessions. Issues of family matters, disputes, delays, a wife battery. Sometimes people are doing this because of the stresses they are going through. So instead of charging the person and putting them in prison, why don't we take sessions them out and be able to take them through counseling? So we have even alternative to incarceration. This can only be possible if we embrace plea bargaining, embrace alternatives to prosecution. Then we say that it's prone to abuse, yes, lack of transparency, integrity, and corruption, which are very big menace in our country. Then sometimes difficult conditions applied in applying for alternatives. So unaambiwa ndio utasema guilty, utafunga 10 years na bado utakuja testify. So those conditions become so tough to this person who wants to get into plea bargaining. As I mentioned, I wanted to just briefly in a minute talk about the issue of sentencing. As I've said, and I'm still repeating, sentencing still remains the part of the judiciary. So it is also a challenge that you can agree on the sentence, but ukienda kule mbele, the person tells you, no, the judiciary says, I'm not going by what you propose. It's a proposal. I will be able to sentence. So that issue of sentencing still also makes people fear to get into plea bargaining because you don't know what the judiciary is going to give. Ladies and gentlemen, that is the end of my presentation, and I've seen a lot of comments on this on the chat. I want to hand it over to our moderator, who is doing a very good job, and I'll be able just to go through the chat and see which areas that I can be able to answer and which areas my senior, who has been also tackling this area of plea bargaining and training lawyers, can be able to tackle. Thank you so much. Back to you.
Thank you so much, Ms. Jemima, for that insightful presentation on the topic of plea bargaining. Correctly said, there are so many chats that are flowing in on the areas cutting across from plea bargaining, resentencing to appeals. And in the interest of time, allow me to share the questions and either you or Senior Counsel, you, Ms. Nima, or Senior Counsel can pick out on questions that you feel best, that you feel best placed to address. So the first one goes to you, Senior Counsel Nderitu. One of our followers says that those sentences, actually that comes from Meru prisons, those sentenced under presidential pleasure, can they be resentenced? Can those sentenced under presidential pleasure be resentenced? Over to you, Senior Counsel Nderitu.
Thank you very much, Katunge. Now, in the Kenyan criminal justice history, we have had convicts whose sentences have been commuted to, say, from death sentence to life sentence, and even now from life sentence to a custodial sentence that then is commuted, and we have had people who are initially on the death row getting out of a prison through the power of mercy, what we used to call prerogative of mercy dynamics. Now, that is a situation, first of all, that I think calls for clear guidelines, particularly given the fact that the death sentence and a custodial sentence are sentences of a fundamentally different character. But then the question, as I understand it, in fact, relates to a special category of persons whose liberty still has been curtailed, and that is those who, on account of their mental health condition, have found themselves detained, but have not been formally sentenced by the courts on account of the fact that the court has found that they were unable to convict them on account of their mental health condition. I don't want to use the word that has been used for a long time, which is insanity, because I have a bit of difficulty with thinking that that is a word that should still be in our statute books. But this particularly vulnerable category of persons would need some clearly focused guidelines that would allow for their reintegration into society if the circumstances that got them to lose their liberty are no longer obtaining. What I'm saying is that, first of all, we need to understand that these are not people that would be, that have been sentenced in the formal way that a person who has been found guilty is sentenced. And therefore, their process is not one that I would want to call a resentencing process, but a review process that that allows their case to be looked at, not the case in terms of the factual circumstances under which the offense was alleged to have been committed, but their case in terms of their own mental health condition being looked at. And if it is found that they are that they can get back to society, then they can they would be taken back to society. It is unfortunate that Article 133 of the Constitution on the power of mercy, and also the Power of Mercy Act, makes no provision for this category of persons. And I think there is an opportunity right there to start or to do some reform work around that. Perhaps when I'm still on my feet, I may take on the other question, which was about whether it is discriminatory for a murder convict to have only one chance to appeal, whereas in other matters that may attract the death sentence, like robbery with violence, there are 2 chances to appeal. Yes, I have no doubt in my mind that that is discriminatory under Article 27 of the Constitution, which provides that, if I may just read it as it is, that every person is equal before the law and has the right to equal protection and equal benefit of the law. So if you are trying crimes of a similar character, like murder and robbery with violence, both of which are serious crimes, both of which attract the death sentence, then it does appear to me that those who are charged with murder, if we read the Constitution purposively, would be entitled to say that they should also have two levels of appeal. And those are some of the criminal justice reforms that really need to be put in place so that you do not find a disparity where there is opportunity for some people and no opportunity for others when they are having to face crimes of more or less the same character. I think I'm done on that, but yeah, I think I'm done on that.
Thank you so much. You just took in a question that I had actually allocated to you. And before you maybe turn off your mic, one of our followers says, can an appellant withdraw an appeal from the Court of Appeal without appearing before the court? And what is the procedure? And why is it that one who has agreed to plead, okay, that one goes to Madam Jemima. So can an appellant withdraw an appeal from the Court of Appeal without appearing before the court? And what's the procedure? Over to you, Senior Counsel.
Oh, sorry. I had that goes to Jemima.
No. Maybe I could read it again now, knowing that it's your question to address. Can an appellant withdraw an appeal from the Court of Appeal without appearing before the court? And kindly explain what the procedure is.
I must admit that that is something that I would just need to very quickly cross-check. Perhaps as Jemima does answer that, because I know that there has been 2 schools of thought. That one, an appellant must appear in court and withdraw the appeal before the court. And the other school of thought has been that an appeal can be withdrawn from wherever. I don't know whether it is settled yet. I just would need a quick minute as Jemima perhaps answers. Yeah.
Very well. Thank you so much. Over to you, Ms. Jemima. A couple of questions on plea bargaining. So I'll try a couple up, those that can be bundled up together. So one of our followers says many people tend to take up the option of plea bargaining as they do not have funds to get top-notch defense. And you may kindly elaborate on the burden of proof. The prosecutors are given benefit of doubt as opposed to the case being determined beyond reasonable doubt, which seems unfair. One of our followers expresses that. As you respond to that, another one says, does plea bargaining hinder the adversarial system practiced here in Kenya? So I'll put 3 questions, then you respond to those first. And lastly, is there a link between plea bargaining and traditional justice system as was used in the case of Mohammed Abdul case? Over to you, Madam Jemima. Miss Jemima, you can hear me? Miss Jemima, don't know if she's still with us. Maybe Bettina could check in with her just to be sure that she hasn't dropped off.
Perhaps as we look for her, I can state that Rule 68 of the Court of Appeal rules provides at sub-rule 1 that an appeal may be withdrawn, that's now a criminal appeal, may be withdrawn at any time before hearing by notice in writing to the registrar signed by the appellant. And upon such notice being given, the appeal shall be deemed to have been dismissed. Then sub-rule 2 says when any appeal is withdrawn, the registrar shall forthwith notify the respondent and the registrar of the superior court. Then sub-rule 3, an appeal which has been withdrawn may be restored by leave of the court on the application of the appellant if the court is satisfied that the notice of withdrawal was induced by fraud or mistake and that the interests of justice require that the appeal be heard. Then sub-rule 4, an appeal may be withdrawn by an informal application in court at any time before the hearing is concluded. My understanding of this, and I think that's why there is some difference, some two schools of thought, is under sub-rule 3. The rules are recognizing that an appeal which has been withdrawn may be restored by leave of the court on the application of the appellant if the court is satisfied that the notice of withdrawal was induced by fraud or mistake and that the interests of justice require that the appeal be heard, which to me appears to suggest the following, that the court needs, or the court wants to satisfy itself as to the propriety of the withdrawal, the circumstances, the actual circumstances, which would be difficult to discern or to confirm if the appellant is not in court. So I think if I were the judge, I would prefer to err on the side of caution, and I would, even if there is a withdrawal, and you know, a withdrawal in writing to the registrar, I would perhaps have the file called up and satisfy myself that there was no fraud, there was no mistake, because an appeal is really serious business. I think I would end it there.
There you have it. Very well put. Thank you so much, Senior Counsel Nderitu. And I see Ms. Jemima has been able to log back in. Ms. Jemima, karibu tena. Before you left, I had floated a few questions from our followers. Some of them were just expressions from your presentation, reactions from the details you gave us on plea bargaining. Maybe just to recap, we had one person say that, Madam Jemima, it seems more of an institutional practice to reduce the case backlog, funds to other cases, and reduce number of people in custody. Prosecutors tend to go to trial for cases they're sure they can win. Sorry about that. That is one of the followers expressing what they feel about the whole issue of plea bargaining. Then down to the questions. Is there a link between plea bargaining and traditional justice system as it was used in the case of Mohammed Abdu? Allow me to bundle it up with one more question. Does plea bargaining hinder the adversarial system practiced here in Kenya? Does plea bargaining hinder the adversarial system practiced here in Kenya? those two questions and any other you could have seen on the chat box that you feel well pleased to respond to. Over to you, Ms. Jemima. I hope we haven't lost her again. Okay, as we continue to wait on Ms. Jemima, I'd like also to remind us to make use of the chat box. Questions will be responded to. One of our followers, Ms. Caroline, asked whether the materials presented.
Yeah, sorry, I'm experiencing some.
Ms. Jemima? Hello, Ms. Jemima, can you hear us? She seems to be having some challenges with her connectivity. As I was saying, as she tries to reconnect, we are kindly reminded to make use of the chat box. The questions will be responded to accordingly. Secondly, allow me to use this chance to remind us of the donations that are we are kindly requesting to the members of public, also our advocates, to make donations towards the visits we'll be having on Friday, that is 3rd September, to the Langata Women's Prison. A list of items had been identified that are going to be shared on the chat box, and I'm going to read them out as we wait for Ms. Jemima. I'll also, in the meantime, request that Bettina shares the screen to project the pay bill number where you can send in your monetary donations. We had a request for both monetary and in-kind donations. So for the in-kind donations, let me just check that up. Just a second. So for the in-kind donations, we request for support towards payment of internet subscription for virtual hearings for the inmate at the Langata Women's Prison, for file cabinets, for filing purposes, of course. And also desks. We request for stationery, toiletry, blankets, and orange wool, yarn, kwa Kiswahili uzi, for knitting the sweaters because the weather has been a bit cold, chilly, and donations of sweaters, the ones maybe you're no longer using, maybe they're in black, blue, are not allowed there. They have to sort of do their own sweaters. So the items that I have listed, and for those who cannot make the in-kind donations, we have a pay bill number that is going to be projected on our screens shortly by Ms. Bettina. You can make whatever contribution will go a long way towards making their stay in prison better. Still on the same note, after the donations, as we wait for the screen, there it goes. So there we have it. You will notice down, our pay bill number is 734-734-626. Then account number, you type in prisons. So we'll appreciate if these donations are made as soon as possible, bearing in mind that the visit will be this coming Friday. That is on Friday. So if you're not in a position to make your monetary donation, we'll also appreciate if you give in-kind donations. And this can be dropped at the LSK Nairobi offices. That is suite number 12, Lower Hill Duplex, Upper Hill Road. I request that information is typed on our chat box so that whoever might have missed the small details of the suite number, the building, they can still get it there. I'll put it again. Suite number 15, Lower Hill Duplex, that is Upper Hill Road. These are the LSK Nairobi branch offices. I don't know if Ms. Jemima is back.
I'm back.
Oh, great.
Yeah,
oh, great.
I'm back. Let me tackle before the internet again goes off.
Sure.
Yeah. Okay. So first of all, there was a question about plea bargaining vis-a-vis the traditional justice mechanism, and both of them are alternative forms of prosecution. Whereas one is handled completely outside the court process, plea bargaining is handled within the court, the ambit of the court trial process. So in traditional justice mechanism, we handle it in various forms. Like for instance, we don't have a structured way of handling an AJS case. We handle it based on community, what the community have been able to develop as their own form of handling matters. Whereas in plea bargaining, we handle it within the court process. So for the case that has been mentioned, it relates to matters that come from Northeastern. In Northeastern, they develop their own way of dealing with the murder cases. And so what this case brought as of great interest is when it was handled outside the court process, like the prosecutor was not aware that that they're doing their maslaha thing, and then now they're coming with a conclusion and telling the court that mimi nataka kuacha kesi because tumesha kubaliana. But the gist of this case was at what point do we bring issue of plea bargaining? Do we bring after the closure of prosecution case or before closure of prosecution case? And do we involve the prosecutor in the AJS case, in the matter that is being resolved outside the court, or do we not involve the prosecutor in such kind of matter? So this is the gist of the case that has been highlighted here. And what the AJS policy recommends, it recommends that if the matter has already been registered in court and you want to settle it outside court, it is important, if you want to choose an alternative way of dealing with the matter, it is important that the prosecutor is informed that we want to settle the matter, then we shall be able to come and give you our taking. So in this case, the prosecutor is not involved, but the prosecutor is just informed. For instance, in issues of compensation outside the court, you come, you say to Mesha Skizana to withdraw. That is the gist of the role of the prosecutor in AJS vis-a-vis the role of prosecutor in plea bargaining. So that is the difference between the two. Somebody was asking about the plea bargaining vis-a-vis the adversarial court system. So when we were doing at the AJS policy, what we asked ourselves, is AJS an alternative, or is it a system that has been living within our community? That's why even when now we come talk about plea bargaining, indeed we realize that AJS is something that has been working within our system. If you look at the Justice Needs Survey, and if you've ever had a look at the AJS policy, we talk about the river of justice. In the river of justice, it's inverted. Yeah, we have inverted the river of justice. Why have we inverted the river of justice? It shows in the tributaries that matters come so many coming into this river. Yeah, but as they come into this river, first of all, some of them are resolved just within the parties. Then a few come to be resolved within the family, at the family level. Then kuna ule mtu anaitwa chief. Chief is a very big person. The chief comes to resolve a few. Then some come to mediation or AJS or through the NGOs or the paralegals. So very few come to court. And so we can't say that plea bargaining has come to deal away with the completely. No, we say yes, this adversarial system exists, but there's very minimal of the adversarial system that we have than the matters that are handled outside. There's so many matters handled outside that very few come to court. But even those few that come to court, we still say there is a case backlog in court. So it is a way of also handling the matters outside the court, but within the ambit of the court premises or the court process, because it has already reached the court. Then there's somebody who has asked, is it a shortcut that the prosecution used so that they can be able to convict people? No. Remember, as I've said, plea bargaining is a process that involves the parties, all the parties are involved. And so it should not be used as a shortcut. The prosecution should not use that plea bargaining process as a shortcut so that they can say that we want just to clear these cases, so let's have plea bargaining. No. Remember, you must have full evidence. This evidence must only point to the guilt of this person. I've used the example of this matter in Kiambu because most of us heard about it, of the lady who killed the husband, who was, I think, a headmaster, or the lady was a headmistress. She was convicted last year by Honorable Justice Ngugi. So in this case, this person who pleaded guilty, who offered to plead guilty, he's the one who actually committed the offense of who did the actual murder. But the planning and everything was done by the wife. So you must have all the evidence. The evidence must point to the guilt of this person. And at that end is when you say you want to enter into plea bargaining. Even the accused person, by the time you're being asked, are you ready to plead? You should say, yes, I participated in this offense, but to this extent. So you're able to explain to what extent did you participate. Sometimes you are just used, for instance, in economic crimes, it is your phone that was used to be receiving money. You didn't know about that the money was illegal, but it is your phone that you gave somebody a number, so it's done that was used to receive money. So it should not be used as a shortcut to justice. It should be able to be used as a way of enhancing justice so that this justice is in a speedier way. For instance, maybe you participated in a lesser manner. Instead of getting the mandatory death that Senior was discussing about, or life imprisonment or 30 years imprisonment, you should be able to get a lesser sentence than what is prescribed in the law. I'm trying to see what I have because I've just missed out where I had written. So link between that one I've discussed. On exclusion of sexual offenses act from plea bargaining. I think not just sexual offenses, the exclusion is sexual offenses and offenses of under ICA, International Crimes Act. So those are offenses that have been specifically excluded from plea bargaining. Now, for sexual offenses, I think the drafters of sexual offenses decided to exclude plea bargaining or diversion and this kind of forms, especially on defilement matters, because for them they felt like this person cannot be able to express herself, yet she's the one who has been victimized. So they looked at defilement as a very heinous crime that should not be handled in form of plea bargaining. However, just to inform us, what I'm aware is there are two things that are happening in the criminal justice system. There's a committee that's looking at reforms of the entire criminal or the legislation that deal with criminal cases. For instance, the CPC, the Penal Code, and this is one of the issues that will be handled. And secondly, on the Sexual Offences Act, there's a committee under the NCAJ that is also looking at some of the things that they can be able to recommend as reforms under the Sexual Offences Act, and this is some of the one of the things that they're looking at. Because sometimes somebody can plead guilty and once a lesser sentence, do we still go with the mandatory? So this also goes with the issue of mandatory minimum and mandatory maximum. So our senior has handled the issue of mandatory maximum, which is the death penalty, not to the extent of even matters that are being applicable in the sexual offenses, so that some judges felt like even in the mandatory maximum, we should be able to handle them in the Morotato way, and we're giving some convicts who are appealing and were being given lesser sentence than what is being prescribed in the law. So these are some of the things that we need to handle in our reforms about the mandatory minimum, mandatory maximum. And the reason why we don't deal with plea bargaining is because the Sexual Offences Act has given us mandatory minimum and mandatory maximum sentences. So even if you plea bargain with somebody, you cannot be able to tell the court, now sentence this person to 15 years instead of life in prison, because the Act specifically gives the mandatory maximum. So that's one of the things that we need to handle in the reforms that are being done within this criminal procedure, criminal justice system. So I've done with the issue of an alternative. Sorry, I'm just looking at the chat so that I save on time because my network was very bad. So I've done with the issue of dealing with the case log. Does plea bargaining hinder the adversarial system? It doesn't hinder any adversarial system, as I've said. It just complements the adversarial system. So is there a link between plea bargaining? I've handled that. Then the issue of prosecutors dealing with it so that they can handle it as a faster thing. No, I've said no, we should not do that. So the question is, why does one who has agreed to plead bargain not allowed to appeal? So once you've gone through the process, unless you are challenging the process, unless you're challenging that you are not informed, you're not aware, it was not voluntary, then you can be able to to appeal. So what you are allowing is appeal on the sentence, that the sentence is severe. You went through plea bargaining, but now you've still been given a severe sentence. You have a right to appeal on that sentence. But unless you're challenging the process, just the same way as where you plead guilty to a charge and then later on you say that you are not aware, the ultra-force acquit and ultra-force convict, those terms, that this process did not allow you to understand what you're doing, and the punishment is severe, so you can appeal in the entirety of the sentence. Just the same way we can be able to appeal when even if you pleaded guilty, but you did not understand, you can still appeal to the High Court and say that, yes, I entered into a plea, but I was not in the right frame of mind. I did not understand. So we have judgments from court in regard to this. So it doesn't bar you totally from appealing, but you must be able to lay a basis upon which you are appealing. Then many people have taken the option of plea bargaining. They don't have the funds to get a top-notch defense. And if you may kindly elaborate for the burden of proof the prosecutors opposed to the case being determined beyond reasonable doubt, it's unfair. I've tackled that. But the issue of course, I know that people say, I don't have money, so I want just plea bargain. Just plea bargain when you have enough, that the prosecution have sufficient evidence on your in the matter. That one goes to the senior on resentencing. Okay. Are there any criminal charges that, I don't know if I've missed out, cannot be plea bargained? I've talked about the criminal charges, and mainly for SOA, I've said it's because it provides for minimum mandatory and maximum mandatory sentences. So when you plea bargain, under SOA, you cannot tell somebody, just go and plead guilty, we shall give you a non-custodial sentence, because mostly we recommend non-custodial, recommend fines, we recommend community service, we recommend the dropping of the charges. So that's the reason why we cannot apply SOA. So I've explained that. What will happen when a complainant wants to withdraw a matter pursuant to Section 204 of the CPC? Is it a matter that the request be approved by the in-charge DPP and specific trial? So you have a right to withdraw. However, you look at what point are you withdrawing? Are you withdrawing after the closure of the prosecution case? Are you withdrawing before the closure of the prosecution case? And then as a complainant, what are some of the things that the charge that you want to withdraw? And that's why you said, when I started, about the restorative justice and retributive justice, there's some offenses that are committed where the complainant is the state. And this we put like economic crimes, things of murder. We say that economic crimes, the complainant is the state, but now there are those ones that the complainant is actually you are the complainant, the specific individual who's like assault, like murder, such kind of offenses. So when you're applying to withdraw, the person looks at, have you been paid, have you been coerced? So there are some certain principles that the person needs to look at before they can be able to say, yeah, you can go ahead. And then what is the position? At what point are you withdrawing? Is it after the closure or before? So that we don't have scenarios where you come to withdraw and yet the person has already closed their case. So the gist of the matter is, the only information the person needs to know is that you have a right as the victim to be able to withdraw, and you're exercising this right, but you are also informing the court that you're withdrawing because you've not been coerced, of course. And remember, on matters of defilement, you cannot withdraw unless you cannot withdraw on matters of defilement because that one can only be withdrawn on the approval of the prosecutor of the DPP, and that has been stipulated clearly under the Act. Okay, so thank you so much. So I'll hand it over to our senior. I think there was 1 or 2 questions, but I hope I've been able to tackle all the questions. And sorry for the interruption that I had with the internet. Back to you.
Okay.
Okay, thank you so much, Mr. Jemima, and thank you so much, Senior Counsel. I see we're very, very much behind time, but we're here to learn. So I'll give you a few minutes to respond to the questions that have been directed to you.
Okay, thank you very much. I think I will be very, very fast as I can. Now, let me first of all thank Mr. Ochiengaya very much and very sincerely for his thought-provoking questions. One of the questions that he has asked is on resentencing, and he asked what happens to people who had used the Morotato judgment to apply for resentencing in the other case that are not on murder and the cases are still active. And I will want to just say that this is the Tower of Babel that I was talking about. And I actually very deliberately decided not to let people understand resentencing, the participants, because there is really no resentencing that can be understood from the kind of scenario that we find ourselves in. And I was doing this so that then I can provoke some thought into starting some process towards understanding this monster that is resentencing, having reason to it, and having logic to it. Because as it is now, and I did say that, I think, early last month in a similar webinar, as it is now, everything is in a shambles. And we really must get back onto it. We must ensure that we are not dealing with people that are on the death row at the expense of all the other prisoners that are there. So it needs to be a movement that is generated both from within the prisons and within the legal profession and the judiciary. And my thinking is that sooner rather than later, there will be need for a constitutional petition to be brought before the High Court to lay bare all the issues and to, have the matter again eventually taken to the Supreme Court. And perhaps that way we will be able to birth rational resentencing guidelines. Now, having said that, again, Mr. Ochiengaya did talk about manslaughter and murder not being of a similar character. And to some extent, I would agree, certainly. But to another extent, I look at murder and robbery with violence as brothers in this sense. One, the punishment is the same, more or less. Now, murder is even being looked at in more lenient terms than manslaughter, than robbery with violence. And I will get back to the question of punishment. But then both of them, I think I can say, and we can all agree, are very serious offenses against the person. And now, so that I turn back to the question of punishment, my rationalization is this, that where we're talking about murder, where we're talking about robbery with violence, the reason why it attracts the same, or more or less the same punishment as murder is this, that you're talking of a situation where a person is armed with a dangerous or offensive weapon, where they're in the company of one or more other person, and then where they may wound or beat or strike or use violence on that person. What we're saying in actual fact is that robbery with violence occurs in circumstances where the likely result will be death. And as a result of that, My thinking is that the ones that thought about the appropriate punishment to be given with regard to robbery with violence may have argued that a punishment that is similar to that of murder is justifiable because then it acts as a deterrent. That's the way I look at it. And to that extent, I would want to say that there are offenses of a similar character. But to the other extent, I think I would also want to agree with Mr. Guy. Lastly, I think is just a comment by Jacqueline Ngutia, and thank you very much. I was actually in my mind trying to come up to remember this decision regarding discrimination, the judgment by Honorable Justice Lasit, now a judge of appeal, Honorable Justices Kimaru and Kimondo, where the court addressed the question of in murder cases and said that it was a historical mistake that violated the rights of accused persons to a fair trial as regards the matters of the right of appeal, revision, or review. And then the Attorney General and the Office of the DPP were given timelines to work on law reforms. I do not know whether that how far that has gone in terms of reforms, but I'm sure that it's an idea whose time will soon be coming. Thank you.
Thank you so much, Senior, for responding to those questions in a timely manner in a very short period. I know there's so much we can say. As you can see, we had intended that the program runs for about 1 hour, 30 minutes, but the questions kept coming in. And the whole purpose of this is learning. So it makes sense just stopping along the way just because of time. But now in the interest of time, kindly allow me to divert all your questions from the chat box to the social media handles that have been shared on the chat box. This webinar is being streamed live on the LSK Nairobi Facebook page. It will be uploaded on the LSK Nairobi YouTube page, so you can catch up. The notes that you might have missed, the notes that were being requested for, can be found on those two channels, on Facebook and on YouTube. Again, I see Martin requesting for the same notes available through the links on our social media handles. For further questions, we've also shared the specific LinkedIn profiles for our panelists so that you can follow through with them, raise the questions with them. If you leave comments on our Facebook page, they'll be responded to as well. So at this point, allow me to bring the webinar to an end, thanking our speakers, Ms. Jemima and Senior Counsel Nderitu, for giving us their time, sharing the knowledge they have. I mean, it's been such an afternoon. I mean, there's so much that you've learned, there's so much you'll still learn. I'm sure if you go watch the videos afresh, you won't fail to get a thing or two that you might have missed. So kindly subscribe to the channel, sign up to our pages so that whenever we have similar platforms, learning platforms, you can always be informed in good time. So to the attendees who lastly checked are way over 100, I want to thank you for sitting in patiently, listening, contributing, engaging with us. And I look forward to interacting with you in other forums, similar forums. To the organizers of this event, want to say a very big thank you. Thank you for ensuring that the masses keep learning, keep understanding the law as is. To the participants specifically, I was excited to see Mary present. They kept coming in and out. That tells you the level of interest. I want to give a big thank you on behalf of Nairobi Law Society of Kenya. So with those many remarks, I want to wish you a blessed Keep safe, keep warm if you're in Nairobi. If you're not in Nairobi, I don't know how it is there, but keep safe, keep warm, maintain physical distance, and see you on our next webinar. Thank you and have a nice evening.